Distinguished colleagues, ladies and gentlemen, many thanks to the Judicial School for your kind invitation to speak to you. It is a real privilege for a judge from Europe to be allowed to address her colleagues from Mexico. It is my first time in your beautiful country, and I'm really impressed by the kindness and hospitality of the Mexicans, and especially our hosts. So once again, thank you very much for your opportunity to speak to you. My name is Simone Kreß, and I'm a judge for more than 27 years now. I started to work as a judge on probation in 1997 and worked in the Municipal Court as well as in the Regional Court of Cologne and in the Ministry of Justice before I was promoted to become judge at the Higher Regional Court of Cologne in 2010. Since 2014, I'm Vice President of the Regional Court of Cologne, one of the biggest courts in Germany, with more than 200 judges working there. As a Vice President, I'm not only presiding a chamber, but I'm also working at the administration of the court. Apart from exercising my judicial function, I have been representing Germany for many years now in the European Commission for the Efficiency of Justice. I do not know whether a comparable commission exists in your part of the world, perhaps as part of the Organization of American States. Whether or not this is the case, I hope that the work of this commission is of interest to you, and therefore I wish to tell you a little bit about it. The Commission was established in 2002 as part of the Council of Europe. Its goal is to improve the efficiency and the quality of the justice systems in Europe. The Commission consists of experts from 46 member states of the Council of Europe. In the Commission, we work closely with legal experts, policymakers, and scholars in order to develop concrete proposals for strengthening justice in Europe. Let me first tell you a little bit about the Council of Europe. It was established in 1949, so 1 year after the establishment of the Organization of American States. And as the Organization of American States, the Council of Europe is an intergovernmental organization. Currently, the Council of Europe comprises 46 states with more than 700 million citizens overall. The Council of Europe must not be confused with the European Union, which was established later and which comprises a smaller number of currently 27 states. The Council of Europe was established to promote and to protect peace, democracy, human rights, and the rule of law in Europe. The Council of Europe also pursues the goals of protecting cultural diversity in Europe and of contributing to solutions for social problems on fields such as environment, migration, and terrorism. Importantly, the Council of Europe works on the basis of intergovernmental cooperation. Other than the European Union, which is a supranational organization, the Council of Europe cannot produce laws which are directly binding upon the citizens of its member states. This means that the Council of Europe does not possess any legislative power. It can only make recommendations. Other than the European Union, the Council of Europe is not concerned with an economic integration of its members into one single market. Perhaps the most important institution of the Council of Europe is the European Court of Human Rights, which adjudicates on the respect of the European Convention on Human Rights. If need be, the Council of Europe can contribute to the enforcement of judgments issued by the European Court of Human Rights. This European system for the protection of human rights is the European equivalent of the Inter-American system for the protection of human rights with the Inter-American Court of Human Rights. The Federal Republic of Germany became member of the Council of Europe in 1950. This was very soon after the foundation of the Federal Republic of Germany in 1949. Germany's admission to the Council of Europe marked an important step of its reintegration into the international community after Germany's terrible wars of aggression during the Second World War. Russia has been a member of the Council of Europe since 1996. Russia's admission to the Council was a signal of hope that Russia could embrace the values of peace, democracy, human rights, and rule of law. But this hope faded with the growing number of Russia's violations of the European Convention of Human Rights and the start of Russia's unlawful use of force against Ukraine in 2014. All hope has gone for the time being when Russia unleashed a full war of aggression against Ukraine in February 2022. As a result, Russia was excluded from the Council on 16 March 2022, so that Russia's almost 26 years membership has ended. Currently, there is work going on with a view to establish, in connection with the Council of Europe, a special tribunal for the crime of aggression against Ukraine. But let's come back to my commission, the European Commission for the Efficiency of Justice, which, as I told you, was founded in 2002. The Commission analyzes the functioning of justice systems in Europe as a basis for improving their efficiency and quality. This includes the following activities. The Commission regularly collects data and evaluates the justice systems of the member states. Let me emphasize that quality control does not, of course, mean somehow reviewing the content of judicial decisions. This is left to the legal process, especially to the appeal chamber. The Commission's mandate is rather to make a contribution that the overall legal, institutional and financial framework to a high performance in the member states of the Council of Europe is conducive to a high performance of the various domestic judicial systems. To that end, every 2 years, the Commission publishes the evaluation report on European judicial systems. I have brought you the last report from 2022, and I'm happy to leave it with the Judicial School to look at it. The next report will be published in October 2024 and can also be accessed online. I will be happy to give you the relevant internet address at the end of my presentation. This report provides both citizens and decision makers with an insight into the performance of the various judicial systems. The Commission's work is, among other things, directed to lowering the barriers for access to justice and to reducing the length of proceedings. In that respect as well, the Commission collects data, and based on those data, it develops indicators and tools which it places at the disposition of judicial practitioners and political decision makers. In recent years, the Commission has increasingly been focusing on the digitalization of the justice system and of the use of artificial intelligence in particular. As part of the Cyber Justice project, the Commission has published a code of ethics for the use of artificial intelligence in judicial systems. The Commission continues to develop guidelines on the use of digital technologies in court proceedings. Turning to another topic, the Commission also promotes mediation as a means of extrajudicial settlement of disputes. Hereby, the Commission wishes to alleviate the workload of the judiciary. The Commission is also running several cooperation programs in European countries. One example is the peer review of judicial statistics, through which member states have the statistics reviewed on the basis of best practices. So it is the country which is reviewed who invites the Commission to look a bit closer to what could be improved in this country. I was part in such a peer review in Croatia and Cyprus. And it was interesting for me to talk to my fellow judges from these countries, trying out to figure out how to become more efficient. In addition, the Commission is working closely together with the European Union and countries in the Western Balkans to evaluate and support the reform process in this region. Let me look a little bit closely at the Commission's contribution to the quality control of the justice system in Europe. The essential standards can be found in Article 6 of the European Convention on Human Rights. The first sentence of this first paragraph of Article 6 reads as follows, I quote, "Everyone has the right to a fair hearing in open court and within a reasonable time by an independent and impartial tribunal established by law of any dispute relating to his civil rights and obligations or to any criminal charged against him." End of quote. The Commission has set up a working group in which I am a member, which is responsible for evaluating the judicial systems of the member states of the Council of Europe in light of the criteria listed in Article 6 of the European Convention of Human Rights. For this purpose, the working group has set up the following parameters: the fairness of the proceedings, the reasonable length of the proceedings, both in civil and in criminal matters, the publicity of the decisions and the transparency of the proceedings, the protection of minors and other persons in need of assistance, the comprehensibility of the procedure and the decision, and the access to justice and legal aid. In this respect, the Commission collects data with respect to a number of relevant categories. The first is the allocation of sources to the judiciary. Of course, if there is not enough money allocated to the judiciary, proceedings cannot be managed properly. Here, the Commission examines the budgets for the judiciary and the costs per case. It also documents the number of judges, of public prosecutors, and of other court staff. And it looks into the technical equipment of the courts, including the degree of digitalization and the use of information technology. It goes without saying that all these points are important for a functioning judicial system. The second category is the access to justice. In this respect, the Commission examines a number of things: the cost for citizens to initiate judicial proceedings, the availability of legal aid and legal advice, the existence of other services that enhance access to courts, such as barrier-free entries and digital services. The third category is the administration of justice. Here the Commission looks into the education and the training of judicial staff. It looks into the judicial ethics and the independence of the judiciary. And it examines which procedural standards are in place in order to ensure a fair trial. The efficiency of the judiciary constitutes the fourth important category. The most important point here is the length of proceedings calculated from the initiation of the proceeding to its completion. In my personal view, access to justice, fair trial standards, and an appropriate length of the proceedings are key. Let me give you some more details in that respect. I would like to begin with access to justice. Court fees or taxes are common for judicial systems in Europe. Parties are usually required to partly contribute to the financing of proceedings. Most countries require a payment to initiate civil proceedings, Luxembourg, Spain, and UK, Scotland being the exceptions. In France, access to justice is largely free of charge, only a few exceptions are reported. and only few countries required court fees also for criminal proceedings. By legal aid, I mean the assistance provided to specific categories of persons in the form of state-funded legal advice and/or representation. An adequate budget allocated to such legal aid is important to guarantee access to justice for everyone, as envisaged in Article 6 of the European Convention on Human Rights. Almost all member states of the Council of Europe provide legal aid in criminal proceedings, but also beyond. Most often, the aid covers legal representation in courts and the exemption from paying court fees. Legal aid can also be granted for additional costs, such as fees for experts, translation fees, or travel costs. In general, the provision of legal aid is dependent on the financial means of the citizen concerned. This may require an assessment of the individual's income and his or her assets. In most countries, it is possible to deny the provision of legal aid in cases of a manifest absence of any chance of success in the proceedings sought. I now move to some key fair trial standards. The right to a fair trial is part of the principle of the rule of law. It includes the right to an oral hearing and the court's duty to provide information. So both oral hearing and the court's duty to provide information. Let me set out first the principle of orality and certain admissible exception to it by reference to Germany's law of civil procedure. I take Germany by way of example only. You can find similarities in other legal systems in Europe. As no judgment can be rendered in Germany without a prior oral hearing. But you won't be surprised that there are exceptions to this principle. For example, judgments following the acceptance of the claim by the defendant party or judgments by default do not require an oral hearing. Two other exceptions are worth mentioning. One is the waiver of oral proceedings by all parties, and the other applies in so-called minor cases. During the pandemic, there was a considerable increase in the number of cases in which the parties expressly waived their right to the hearing. During the Corona period, the possibility of waiver almost turned into a practical necessity in order to settle lawsuits. As far as so-called minor proceedings are concerned, it is possible under German law that the competent judge at first instance decides to proceed without a hearing in proceedings of, so to speak, a lesser financial value. At present, the exemption applies in cases of up to 600 euros. I think this is an equivalent of about 12,000 Mexican pesos. This exemption from the principle of orality was introduced in 1990 with the aim of simplifying and speeding up proceedings. The exemption in cases of minor importance works as follows. Even when the judge indicates to proceed without an oral hearing, each party can insist on such a hearing. But this must be done by way of an explicit request. Silent counts as consent to the written procedure. Interestingly, an explicit request for an oral hearing is only rarely made. One cannot know for sure why this is so, but one reason might well be that legal representation by a lawyer is not compulsory in these proceedings of minor importance. It is thus possible that a layperson who is not represented by a lawyer will often not be aware of the disadvantage of not being able to present his or her case in person before the judge. The legislator has accepted this situation in the interest of speeding up and facilitating proceedings in cases of smaller claims. In addition to dispensing with the need for a hearing, The judgment can also be shortened, provided that no appeal is allowed. This simplified procedure is widely used in practice, and it facilitates the day-to-day work on the first instance judges quite significantly. Please note that a single judge at first instance in Germany has to deal with 600 to 700 cases a year. You can see here the attempt to strike a balance between the principle of fair trial and the need to uphold an efficient judicial system. A second procedural standard to ensure the fairness of the proceedings in the court's duty to provide the parties with information where necessary. Let me take again the German law of civil proceedings by way of example. Here, the court must point out to the parties when facts are missing or there is insufficient evidence if either of both concerns points that are essential for the decision. If a party makes an unclear or incorrect submission, the court must address this and give the party the opportunity to explain or correct. The court may also put questions to the party concerned in order to better clarify the relevant facts and to eliminate misunderstandings. Particularly in cases where a party is not represented by a lawyer, the court must point out formal errors so that the parties can effectively exercise their rights. The court must not base its decision on an aspect that the party has obviously overlooked or considered irrelevant without having pointed this out beforehand. The court's duty to inform is intended to ensure that the proceedings proceed swiftly and efficiently. By pointing out ambiguities or omissions, formal errors or gaps in the parties' submissions, things can be rectified before a court judgment is reached. This prevents delays and unnecessary repetition of procedural steps. All this is intended to guarantee that no party is disadvantaged by formal errors or ignorance. It is meant to contribute to equal opportunities and to ensuring that all parties can make the best of their right to be heard. However, the court's duty to provide information in civil proceedings has limits with a view to the essentially adversary nature of the proceedings. In particular, the court may not provide either party with detailed legal advice. It must certainly avoid creating the appearance of acting like the lawyer of one of the parties. Instead, the court must remain neutral. In other words, the requirement of fair proceedings does not absolve the parties in civil proceedings, and especially the applicant, of their responsibility to present the relevant facts and to satisfy the burden of proof. To the extent that the court has a duty to provide information, its modest aim are only to ensure that proceedings are conducted correctly and swiftly by addressing ambiguities or formal errors in good time, and to ensure that no party is disadvantaged due to a lack of information and met with a decision by surprise. Let me finally say a word on the length of the proceedings as a core indicator of the efficiency of proceedings. The right to a reasonable length of proceedings is, as enshrined in Article 6 of the European Convention of Human Rights, to protect the parties from excessively long court proceedings. Justice delayed can amount to justice denied, as the saying goes, and, indeed, delays in the service of justice can lead to considerable personal and financial disadvantages for those affected. For this reason, the European Court of Human Rights has ruled in many cases against member states that have violated the right to speedy proceedings. In German law, an important innovation was introduced by the legislator in 2011. Prior to that, citizens did not have a specific legal remedy for complaining about excessively long proceedings. The 2011 law, however, has created legal protection specifically for the advent of excessively long proceedings. It enables those affected to complain about the length of proceedings and, under certain circumstances, to claim compensation. An initial complaint about a delay is a key element here because it draws the court's attention to the excessive length of the proceeding and provides it with the opportunities to speed up the proceedings in order to remedy the situation. Only if the court does not respond appropriately to such a complaint and the delay persists, a claim for compensation is warranted. Here again, the Commission has set up a special working group. Its aim is to recommend concrete measures for improvements of domestic practices. Importantly, the working group has suggested the introduction of time frame management systems for courts. This system should make it possible to monitor the proceedings so that backlogs can be identified and dealt with as early as possible. Of course, here as in other cases, there is often no one single solution which fits for all national systems. The working group rather tries to come up with different solutions which duly consider the particularities of the relevant domestic procedural system. I wish to leave it here. I hope I was able to give you a useful insight into the work of the European Commission on the efficiency of justice. Please be reminded of the copy of the last report of the Commission that I mentioned before. In this report, you can also find the internet site of the Commission, which provides more detailed information. I should be very pleased if there could be some cross-regional exchange in the future, and I wish to thank you once again for your kind invitation and your attention. Thank you very much.